thank God for this opportunity once again to share my views and by extension the views of many of our residents in Marco City to reflect their dreams and aspirations. Mr. Deputy, before I get into the substantive presentation, I'd like to congratulate the local government officials in the city of Freeport. I had the honor of participating in their recent dedication of the EOC. That is, they have worked jointly with others to create a space, Mr. Deputy, where all of our emergency operators will be able to work in preparation for hurricanes, during hurricanes, and in the aftermath of hurricanes. And I thought they did a remarkable job taking care of a very significant need in our community. Our colleagues present, the member for East and Central, we stand with all of our local government practitioners and we celebrate and congratulate the work of the entire team led by Chief Consular Fraser Gibson, Fraser Bullard, who has done a remarkable job with a team with persons who have attachments politically to all sides. And they have worked to do something quite significant in Grand Bahama. I would also, Mr. Deputy, like to extend condolences to a number of families throughout. Allow me to single out just a few today. Grieving, our hearts go out to you, and you are in our thoughts and prayers. Anthony Huck Williams, a number of us attended his funeral, the John Canoe rush out, which was massive downtown in Freeport, and to say how much we've appreciated the contribution of Anthony Huck Williams, who was laid to rest just recently. And Judy Barry, again, outstanding mother, grandmother, an outstanding person in our community in Grand Bahama, and to extend condolences to the family of Sharon Tomlin and Ella Mae Duncombe Richardson. And once again, we in the Free National Movement continue to remember and celebrate one of our founding fathers, as we've done in this place in an earlier sitting, Dr. Elwood Donaldson, and to say thank you to his family for lending him to us. Mr. Deputy, while driving here this morning, we were reminded of the challenges that so many motorists are experiencing in New Providence. And we sympathize with the staff of road traffic. And we were pleased to hear this morning the acting minister mention certain improvements that he has indicated is occurring now. We raised just recently the most unfortunate situation with the license plates and the fact that there has been a tremendous backup. And it is our hope that the distribution, which he indicated will begin shortly, also means that all of the equipment issues have been solved and that the licenses, I understand 2 of the family islands were providing or supplying New Providence with driver's license, and it is our hope that that means the printers locally have been repaired. I raised recently the issue that has been mentioned, hoping to get clarification on whether it was true that the New Zealand company has been owed a substantial amount of money, and that may account for why certain corrections to license plates have not occurred in a timely fashion, inconveniencing a number of Bahamians who travel. It is my hope that at the end of the presentation, the minister might bring some clarification to that issue. And while we know that a new facility is being pursued, as it has been pursued in the past, It is our hope that we could relieve the pressures on Bahamians, that all of the facilities that are not cash, that are not accepting cash would, for a temporary period, accept cash to ease the burden on the individual centers. It is also a recommendation by some who have served at the highest level in road traffic that we give consideration that the original position that persons living in the east would go to the Elizabeth Police Station, that might be considered. The ones in the south go to the police station in South Beach. The ones in the west go to Cable Beach Station. And that Southwest New Providence go to Carmichael Road, again as a temporary measure. And that new vehicles go to Fort Charlotte. This may in the interim avoid high rent and provide a service to those individuals. Mr. Deputy, we are here because all of us, I believe, policymakers and the general public, that we are all saddened and we are outraged at the high level of crime in general, but violent crimes in particular. Several of us in this place have mentioned how our own families have been impacted, but certainly all of us know persons who have been affected by the high rate of crime and the fear of crime. Prominent citizens, some of whom are assigned a protection detail, comment on not enjoying the full quality of life that their stature, their resources ought to afford them by virtue of the fact that they are unusually careful about where they go. And the truth is, we are here today because of the high rate of crime, and in January, possibly the second largest number of homicides, carnage of our children, our family members in the history of the country. Second, the first being, I believe it was April or March of 2022, where there were 22 murders in that 1 month. This is an indictment of our whole society. It does take a village to raise a child, and we are a part of that village, which is why the Free National Movement has consistently not sought to make the point that the PLP created crime. It's nonsensical. That's not our view. Our view is that in many ways, all stakeholders have to share the burden of responsibility for why we are where we are. What we have asserted is something that is no different than what the leader of our country has asserted before sitting in the chair that he is in, where he himself has asserted, really, that any government that lacks the capacity to provide the most basic and number one responsibility, which is peace and safety for their citizen, is ill-suited to continue to hold that position. As I paraphrase a statement he made in this House in a debate during the time we were in government. And so what we are saying today is that the Prime Minister and his colleagues, while not responsible for the genesis of crime, are responsible for the overall coordination of the efforts of stakeholders from all walks of life to make sure that we are able to tackle the issue of crime from prevention, detection and policing, prosecution, the dispensing of appropriate and measurable punishment, and then, of course, rehabilitation. Those pillars are not PLP pillars. Those are pillars that predated this administration, that multiple reports that we have received, whether it's from the United Nations or from the WHO and PAHO, who made recommendations of those categories that governments are directed or are advised to look at in order to deal with this social disease. And so we are only saying to this government what has been really said in many countries, that you have a responsibility, if you are to lead, to address the peace and security of your citizens. And we've contended that this administration has failed in that regard. And any effort at any point in this administration where they're able to correct the trajectory that they're on as it relates to peace and safety, they will meet us willing and ready to work with them. Today is no different, which is precisely why my colleagues have taken the time to study the legislation, to take advice, and to give measured comments about what they believe is missing. And when we commented on what is missing, we did not rely only on our wisdom or expertise. We consulted case law locally and internationally. We listened to those who are eminently qualified, and before this administration came to power, they held these folks up as heroes or heroines in our country who understood the social dynamics but appreciated the separation of powers and made recommendations on the way forward. Those recommendations made as it relates to bail were good when they were in opposition. However, it's bad now that they are in government and the very same persons who took a stand when Dr. Minnis was in the chair, who took a stand when the Honorable Hubert Alexander Ingram was in the chair, all of a sudden, those brilliant and prominent voices are mistaken. They are misguided in what they are saying to this government. But it was celebrated and extolled back then. And so, again, the question is, have circumstances so changed that the present opinion of persons who sit on the bench, those that are part of the Bar Council, not just defense attorneys, but attorneys in general, have their opinions all of a sudden become null and void when they make the point that the government's attempt through legislation to restrict the discretion of judges is a bad thing. It is a chipping away of judicial independence. We have contended in this place before that this is not a government that is interested in co-equals in governance. We see it in the parliament, bullying of the speaker or attempts to provide, in our view, bad advice on very fundamental things. We see it in the passing of acts where the government seek to pull from the legislature powers and accrue those powers unto itself. We see it in the PAC as but one example, where when we were looking at the suite of financial bills and the amendment to the Financial Management Act, where the PAC had purview, all of a sudden, those powers were being pulled from the legislature overseeing those particular responsibilities and the Fiscal Responsibility Council, but another example. And so we are concerned about the overreach of this administration, the confidence, the misplaced confidence that they see the world completely better than other arms of government, better than the parliament. So strong is this view by this prime minister that you could only have a handful of backbenchers. There is no check on the power, and if persons wish to keep their position, they would do well to go along and pray for an elevation, pray for a promotion to this cabinet. And if you're on the backbench, you rule or you pay a price. That is the reality of this administration. And so even the legislature is weakened. So this parliament does not enjoy the kind of independence that would be useful to a thriving and growing democracy. We are concerned. We are concerned that this could extend to the judiciary, and this is the point that members of the judiciary are making. We are concerned. I regret that appointments were not made prior to us admitting office so that we could have, we could be reasonably assured that unbiased persons would be placed in the chair in order to execute the work of government. And we have confidence in our Bahamians, and so we believe that those that will be appointed will have the moral fortitude to resist any attempts that may be made by an executive to influence them. And so we look at our judiciary as independent. We respect men and women who are on the bench, and we are hoping and praying, despite any efforts that may be made by this administration, that they will continue to, in an unbiased way, discharge their duties. And so this amendment fits within the context of those words, Mr. Deputy, that we are here because of the carnage of our people. We are all rightly outraged. We all want things to work better to save the lives of our children. The reality is, many Bahamians would rather almost anything to happen if they believe it gives us a reasonable chance of saving lives. What is wrong with what this administration is doing is that it is giving the impression that this amendment will accomplish something that I believe they know full well it will not accomplish. They continue to overstate the potential impact of the tinkering around the edges that they are doing in any number of ways, Mr. Deputy. Again, let us not just refer to what those who are eminently qualified in our community have said. Let's just go to the words of the very persons who themselves, Mr. Deputy, have moved these amendments. And I will not dwell on this because, again, this is not going to be a discussion about, where do we stand in just the final vote. We support measures that we believe will move the country forward, and we want an honest, sober conversation with the population, and not to give them the false impression that something that may be tinkering around the edges. Some argue that will take us backward, because what it will be doing is accruing more power to the legislature, power that is rightly vested in the hands of people who are eminently qualified to exercise discretion, which are justices. But let's look for a moment and ask the question, how is it, with all of the speakers from the government who have spoken before, that they did not take the time to lay out the compelling data that brought them to this point where they are absolutely convinced today that these particular amendments are amendments that's going to save lives. So the 42% or 30 persons or thereabout who died while out on bail, they didn't bring the compelling data to show that these amendments, the way they are structured, were likely to have saved all of those lives if they had had their way, or the vast majority. We listened to the speakers carefully. I think the only stat we really heard was that about 42% of persons who have died were out on bail at the time of their death. That's what we heard. And even that does not answer the more in-depth analysis of that. In other words, how long were they on remand prior to being released, for example? Because obviously, if you don't have speedy trial, which was one of the recommendations that is recurring from the various persons who have expressed concerns about the government approach, then you are obligated to give bail. How many of them have been on remand 5 years, 6 years, or longer? How many of them were, in fact, guilty? Because unfortunately, in the Bahamas nowadays, once you are picked up for a particular matter, it's a mark. And the streets may not know if you've ever been cleared by the police, but the street believes is you. And there's a price. Again, just to narrow the discussion, we are talking about, for the 42% of cases of murder, those persons who are out on bail, the question is, why wasn't the data brought? Because we believe, as the government claims it believes, we believe in evidence-based decisions, driven by what studies they have conducted, what they know, the intelligence that they have gathered. What amount of those persons who died out on bail did the government object to them actually getting bail? Because again, one of the concerns is that if, as we believe, there are provisions in the present law that if there's a perception by the government that a judge is being liberal in their granting of bail, the government reserves the right to object to that bail. And if the argument will come and wrap up that 50, 60, 80 of the persons who are out on bail could have been saved, then the question is, why didn't this administration, armed with that knowledge, go and appeal every one of their bail? So right now, have they moved in mass to appeal the bail of those that are presently on bail? But again, I digress for a second. What has happened between the beginning of this year and now that would have caused an attorney general who would say at the beginning of the year, January 12th, it is carried in the press, that the attorney general says there's no need for bail. This is just January of this year, no, not 1948 when the Clare Hold and Bill program was conceived as an anti-insurgency strategy and then later developed further. And we believe you could adapt anything from overseas and bring here, and it may be beneficial. That's not the point I'm making. I'm just saying this is just this year. What has caused an eminently, his words, qualified attorney, senior attorney, in January to say no need, no change to the Bail Act necessary, and only, you know how they say in cartoons, moments later, for him to then come and say, this is now January 25th. Oh, what that's less than 25 days. That looks like a week and a half later, AG, hardline amendments to the Bail Act is necessary. AG defends previous position on Bail Act. Now, I would not want to call this flip-flopping because it is in the realm of possibility that such compelling information could have come about to cause him to alter his position. But what we are saying is that information hasn't reached the Parliament. We haven't yet heard the information on what accounted for no less than the Attorney General, no bail needed, to all of a sudden, hardline amendments on Bail Act is necessary. Absolutely incredible. But he's not the only one. No less than the CEO of the country has previously, when looking, I believe it was, at bail amendments that we put forth in a rather well-written presentation, again expressed his views about bail that differs in a significant way from what his views are today. It appears to me, unless I misread it, that Cat Island views today is largely different than the views he held. Was that in 2011, I believe they were debating the Bail Act? And so Davis delivers opposition position on crime bills. And one of the things that was said is that until our system is fixed, however we tweak the Bail Act, will not prevent the grant of bail to persons charged with serious crimes. The only answer to this vexing question is to be able to try persons within a reasonable time. That's the long and short of it. That's just one piece of like I said, this presentation is a treasure trove of information. And again, it's not uncommon to us to hear a reversal in position. We experienced it in the PAC. Yes.
The chair recognizes the honourable member for Cat Island, Rumkey, and San Salvador.
I wonder what the statement he's made. I remember quite vividly the contribution I made there. There's one thing is I don't flip-flop, right? That is dealing with the grant of bail. I said tweaking the Bail Act will not prevent persons from being granted bail. What is different, what I'm saying different today? What am I saying different today? Nothing different. Right? Because the tweaking of the Bail Act is not to fetter the discretion of the court to grant bail. So the question of bail and fixing the system is still an ongoing exercise. It is practically dysfunctional. You just need to sit and think and understand and appreciate what is besetting the administration of justice. So, for example, a member speaks about having a trial within a reasonable time. Well, if you think about the number of murders that have occurred over the last 10 years or more, well, don't go 10 years, let's say 5 years. What was the average per annum? About 100. That's about 500. A trial for murder today is taking 2 months. So that's over 1,000 months required to get the trial complete. How many years is that to be able to kill that backlog? Is that possible in the circumstances? Think about it. See, it's not just, you're talking about the surface, but there are deeper issues like that is putting pressure on the court for the exercise of that discretion. And so I don't see how you arrive at the conclusion that because I said tweaking the Bail Act, right, will not prevent persons going on bail. It's so different from what I'm saying today. All we're saying is when you're granted bail, right, and you breach the conditions, that person has to come back into the court to consider whether they ought to stay on bail or be released. And we are saying, it's our view that once that happens, I don't think a court will be a proper exercise of the court's discretion in circumstances that are clearly an affront to the system to allow that person on bail.
Prime Minister, thank you very much for what sounds to us like an adjustment in your earlier statements. But sorry.
Let's continue to be honourable, man. How is it that how am I adjusting my statement?
Prime Minister,
Honourable member, is this a point of order?
let me give me an opportunity. Prime Minister, you and your team today have spent a considerable amount of time giving the impression that these amendments are about the automatic revoking of bail once somebody has violated the terms of their bail, when in the reality it is not an automatic revocation. Those persons have to go back before the court and have to determine if they're going to plead guilty to what they're being accused of as a revocation, or they're going to plead not guilty, which means this is another layer of trial. So it's not automatic. Let me finish the point. Let me finish the point. I'm not yielding to you on any. Let me finish the point. I listen to you. Listen to me for a moment.
Honourable members, the chair recognized the honourable member for Cat Island,
It is not
Rumkey.
automatic. It is
You're
not
starting
automatic.
from the
Honourable
wrong premise.
members.
The bottom line is, it is not automatic. It is not automatic. And in fact, one of the reasons we are going to propose some amendments is, again, at the end of the day, we do not believe that this government should continue to overreach in a matter that will not accomplish the outcome that they are trying to give the public the impression that it's going to have. And the Prime Minister just now in his intervention, when he talked about the complexity of what we face, the question is, why doesn't a government that is so concerned not come to this Parliament with a select committee so we can have a full-throated, comprehensive discussion with stakeholders from throughout this country, talking about the underlying issues, talking about the preventative methods, talking about policing and detection, talking about the appropriate punishment, talking about rehabilitation. If you are serious, rather than tinker, bail would be a subcomponent of those broad discussions that give all the eminently qualified and concerned and interested parties an opportunity to weigh in. So yes, we agree with the member for Cat Island that there are very complex and underlying issues, but that's not what we're here doing. We're here tinkering around the edges with bail. Bail that they just flip-flopped on in less than 12 days. Just in January, this was a no-go. In fact, one of the statements you make about bail too is about, if you want to, trick the public or titillate the public by bordering with the Bail Act, feel free to go ahead. But that's not where the real problem is. The real problem is in the way the cases are prepared, the timeliness with which they make it before the courts. The failure, as the Prime Minister put it, and I thought it was so touching in the moment, except we knew the facts, when the Prime Minister said, sometimes somebody is granted bails and then only seconds, moments later, you then discover that they had another charge on them. Well, whose fault is that? Should that not be something the prosecution knows? Shouldn't that be something that all of those who are preparing the case know? Shouldn't we then say to the judge, by the way, the person who's before you at the moment has other matters that they are facing charges on? Again, the point is, let's tell the public the entire story. But back to this wonderful commitment I'm hoping I heard the Prime Minister make. The wonderful commitment is we are prepared to have a select committee, to have all stakeholders weigh in with recommendations and share their views on the way forward in every area of our development. The question is, if this was as urgent as Yamakro mentioned, if this was as urgent, how do you manage to get here 2.5 years later with this? This is something that could work. This is something that's powerful. But 2.5 years later, you just discovered this? What did you miss at the beginning of the year when everybody was strong by saying it's a knee-jerk reaction? It's not about bail. It's about these other things. And we have now put forth, in a matter of days, multiple plans. The reality is this administration is facing tremendous pressure from a population that is no longer impressed by the public relations campaign, and they want a focused Prime Minister who is attentive to the details on how to coordinate all stakeholders, to make sure he doesn't have rogue ministers doing their own thing, to make sure that he and the AG are on the same page when they talk about the same issue, that he and the Minister of National Security have the same perception on whether we're in a crisis or not in a crisis, that he and the Minister of Finance have the same priorities so we could know what needs to be funded in order to take care of the trauma that's going on in the country. What we see is a disjointed cabinet that's led by a Prime Minister, while smart, not focused on the day-to-day work. And what we need is an administration that is on the same page about this incredibly important priority for our country, which is to save lives of our children. No amount of whistling is going to do that. It's only hard work, every day, focused work, working with stakeholders from throughout this country that's going to change the trajectory that we are on as a country. So we have multiple comments by persons who have served in the Supreme Court, the Court of Appeal, who have worked on the bench, persons who are practicing, members from civil society who are all saying, we are prepared to work in tandem with this government. Let us now take what you have reduced to paper and let us execute it in order to save lives. Mr. Deputy, thank you for this opportunity to present these views. And my final challenge to this government is settle down, do the hard work. This is serious business we're dealing with. And you should reflect the fact that this is serious business by bringing all stakeholders to the table and working on behalf of the Bahamian people.
Thank you, Honourable Member.